how many years does it ideally take to start your independent practice? It is said that it takes 10 years to become successful in this field, which is quite discouraging. Uh, how does someone deal with this and the thought of being financially independent?
No, sorry, the last bit I didn't get.
How does someone deal with it while wanting also to be financially independent?
Okay, that's a very, very good question, practically speaking. Once again, a question which a lot of young people have asked me. The answer is simply this. There is no fixed time limit for when you will succeed in this profession, or when you will feel that you have reached a stage of success in this profession. 10 years is just some limit which some gentleman thought was proper. Things are very subjective. In general, I can say only this. The time limit for becoming successful or earning has shortened as time has progressed. So the time it took me to start earning something decent was much less than the time it took my senior. And that was much less than the time it took his senior. So you will find that you will be able to make a decent earning in a few years' time. Now, whether those few years for you is 2 or 3 years, or whether those few years for you sometimes can extend up to 10 years is really very, very, very subjective. It will depend on yourself and how hard you want to work. It will depend on the senior you have joined, how encouraging he is, and how much he has been able to assist you in your journey in the profession. It will really depend on maybe your family background, your contacts, and etc. If you are from a lawyer's family, it's very much easier. If you already have contacts, it's very much easier. For the rest of you, it's difficult, but it's not impossible. I came from a background which has no lawyers and no family in it. And I don't think I've done badly. So don't feel discouraged. But give it a good shot with your whole heart. And maybe it will be much less than 10 years. You could be happy in 3 or 4 years. But it really is a very subjective matter. The only concrete advice I can give you is this. If you need to be financially independent, or you really need the money, you don't have the savings for it, then maybe you need to be a little more cautious while going into counsel practice. If you have a bit of a cushion, it's obviously much easier and you really don't need to think twice about it. But if you don't have the cushion, then it could get a little difficult if your practice doesn't pick up in the short span in which you would like it to pick up. Okay, Petras?
Yeah. The next question is, what happens in the scenario where a witness turns hostile? What should the advocate do next?
Well, to answer that question, in the first place, let me tell you that you should have been careful right from the beginning. It is not difficult normally to know which witness is going to be hostile. In the sense that if there is a person who's reluctant to come forward, or if there is a person who you know that when he comes forward, he is going to perhaps give evidence against you, or he's going to be sitting on the fence and saying things this way and that way, etc., etc., please don't call him as your witness. So the first thing you have to do is you have to be careful in choosing your witnesses. A person who's going to give evidence against you is not really your witness, he's the other side's witness. So you should not call such a person. But having said that, if a witness does turn hostile, then you don't have a choice. You have to cross-examine him whole hog. I had to do this in one of my testamentary matters. And the Evidence Act provides for it. It doesn't say that you can cross-examine the witness, but the words used, I think it's section 154, and the words are that you can ask questions in the nature of cross-examination to your witness. So you no longer need to be nice to him, and you can cross-examine him because he is no longer your witness, he is hostile to you. So you must then proceed with a full-fledged cross-examination of this witness. But obviously you understand what I say when I say that you must prevent getting such a witness in the first place, because you're just making a lot of extra work for yourself by getting a witness who's supposed to be yours, then having him declared hostile, and then cross-examining him.
Okay.
Yes.
Next question. If a case is filed and the defendant comes to you to brief you, after studying the case, it seems that the case is not in the favor of the defendant, and you're on a weaker side. How do you argue such a case and move it ahead, basically?
Great. Okay, so this is one of the, you see, I've made some notes here, but unfortunately, I've not followed all of them. And this is one of those things which I was going to address you with, but I didn't manage to do it. What do you do when you have a not so good case? Well, my answer to you is very simple. It depends on the individual. There are some lawyers who just refuse to take cases which are not good. I personally don't believe that is right. I don't think that is right from an ethical point of view. And I don't think that is right even otherwise, because you will often find that difficult cases make the best law very often. It's because a lawyer has taken a difficult case and managed to convince the judge about an important point of law that you will get a great decision very often, or a great judgment. And that is one part of it. The other part of it is, to some extent, we are professionals, and to some extent we are like doctors. And I wouldn't like my doctor telling me, listen, this disease is just too far gone, I'm not going to treat you. That you can't do that. You shouldn't do that. And you must take up, I believe that by and large, you must take up whatever comes to you. I would, of course, not take up a case only if I know for a fact that the case is dishonest, or I know for the fact that my client he admits he has done something grossly wrong. And therefore, with that knowledge, I would not take up a case. But otherwise, if it's just a difficult case, that is not a ground to refuse it at all. When you have a difficult case, you just put your head down and do your best. You not only do that, you would have to get out of that, you would have to think out of the box. You would have to think differently. You would have to see if you can slot your case in a different manner and show it's unusual, or show that it has some aspect which has not previously been considered, and why it's not just something run of the mill, and why it is not something which should just fail based on the existing law or on the existing position, and how it is something unique and raises a different issue. And you would have to, obviously, depending on what the case is about, look up law and try to make something more out of it than what it is.
Okay. Another question. Could you also throw some light on out-of-court settlements? What if in the course of proceedings, or once a legal notice is served, the defendants propose a settlement amount of a certain value which is large, but not as large as the claim amount? Can you continue the legal proceedings and show the amount of settlement as an admission of guilt, or what should you do?
Correct. Now, interesting question. That will depend on the settlement itself and the terms of a settlement. Now, normally when parties settle, they're not just going to settle without some documentation. If a matter is already in court, then the way we settle matters is we file consent terms most of the time, which will have detailed provisions for the basis of the settlement. But your question is, what happens if you've sent a notice and the matter gets settled? So even if you've sent a notice and the matter gets settled, if one party is paying the other, or if some actions have to be exchanged, taken by both sides, all this would normally be recorded in something like a settlement agreement. So both parties would have recorded, party A is to pay party B this, party B is to take these actions, 1, 2, 3, 4. These actions must be taken in this much time. After these actions are taken, the matter will be treated as settled, and no party will have a claim against each other. Now I come to your other question as to what if the settlement is for a less amount and I still want my full amount? The answer to that is very simple. You can't have a settlement unless the other side agrees to the terms of that settlement. So in a given case, the other side may say, listen, this is less than your claim amount, but this is what I'm giving you. And on my giving this to you, I want a full and complete discharge. You can take it or you can leave it. In which case, obviously, you have to decide whether you're giving a full discharge or not. On the other hand, a party may say to you, okay, we have 3 or 4 different kinds of disputes. I will take this amount from you and I will say that these first 4 disputes which we have are completely settled and you have paid me for it. As regard the 5th dispute, that is still left open. I can still go to court and sue you for it and you will be okay with that. And your settlement agreement will therefore provide for that. It will say that there were 5 disputes, 4 of those disputes stand settled, and it will provide that the 5th dispute is not settled. Parties are free to act and take actions in furtherance of thereof as they deem fit. After that, you can obviously file your case or you can take whatever proceedings you want. So the point I'm trying to make to you is most or almost all settlements will have some kind of a writing which record what goes on.
Okay. One more question. An affidavit under oath is necessary to be given to the court by both the parties. What happens when one of the parties is proved to have lied on the affidavit after the case is over? Does it amount to perjury?
Yes, if he is proved to have lied, obviously it would amount to perjury, and then perjury proceedings can be taken. But this doesn't mean that every little statement can be said to be a lie, in the sense that obviously the plaintiff has a case, the defendant has a case, and one of them is going to succeed. That doesn't mean that the other side has lied about everything else that he has said just because they have lost the case. So just the validation of one side in either having the suit decreed or the suit dismissed cannot be equated to the other side having committed perjury at all. Perjury is a very specific provision about a deliberate lie, and a separate application would have to be filed for that, and that would have to be then proceeded with separately on its own merits.
Okay. And we got just one final question on the career advice kind of topic. Does corporate experience help in litigation practice? I think they mean corporate law.
Correct. Once again, my answer is yes, of course it would help, because any knowledge you gain always helps you in your practice as a counsel or as an advocate of any kind. The question is only this: is it worth the time and effort you have put into getting that additional experience or knowledge, and for that period of time not having pursued your counsel practice? That is what you have to weigh. Just in general, of course, the more knowledge you have, the better it is, even if you're a counsel. I know many counsels who have passed their solicitors exams, who therefore know a lot more, have studied a lot more in detail on many acts. So that obviously helps them. But what you have to weigh is that when you're going to do those additional qualifications, you're going to take away 1 year, 2 years, 3 years, and you're going to start counsel practice that many years later. And therefore, your gestation period is going to be longer, etc., etc. And that's what you really have to weigh.